That's great. Great to see you back. Welcome. We're here on day 2 of World Arbitration Update, our China Insight Conference here in Beijing at the Beijing Arbitration Commission's Beijing International Arbitration Center. We're progressing now to our 7th session, which is titled The Participation of Chinese Parties in Investor-State Dispute Settlement, ISDS mechanism, Chinese investors applying ISDS to protect their investments worldwide, and China as a respondent host state. So lots to go on there. We've already had some discussions of ISDS related issues in our discussions on state enterprises and on renewable energy. I'm very much looking forward to further discussion of these very interesting and timely issues in the international arbitration world. It's my pleasure to introduce our moderator of this panel. Wen Die is our moderator, and she is currently representing and advising clients in arbitrations here in mainland China, Hong Kong, Singapore, the United Kingdom, Sweden, and many other jurisdictions, as well as lawsuits here in the courts of China. Wen is proficient in dealing in cases in both Chinese and English and has handled hundreds of arbitrations as counsel and as arbitrator, case administrator, award scrutinizer, I understand, at CTAC, as well as addressing topics including international sale of goods, joint ventures, equity transfers, fund investment, energy, construction, and real estate. She has represented clients in all of the major jurisdictions, including under the CTAC rules, UNCITRAL rules, the HKIAC administered rules, ICC rules, and the SCC rules. So a very experienced arbitration practitioner. And Wen had the distinction, interestingly, of serving as an emergency arbitrator in CTAC's first case under the emergency arbitrator procedures. So very interesting experience, which look forward to hearing more about. So thank you very much for moderating, and thank you panelists very much. This is going to be a great panel and great topic of discussion, and I'll pass the microphone over to Wen, and looking forward to sitting down and listening to the great discussion. Thank you.
Thank you very much for the very kind introduction about me. Before we dive into today's afternoon's panel discussion, I would like to first give us a quite general overview of the topic. Before this session, I do a little bit of search, and it turns out to me that now up to date, there are already 29 investment treaty cases where Chinese investors as the claimant or where the China as the respondent host state. And among these cases, more than half of them happened after 2020. So we can see that in recent years, it's really a high development in the ISDS region where China has been actively involved and also Chinese investors has been actively involved. So that's why we have this afternoon's panel discussion on the Chinese participation in the ISDS system. So as a privilege of moderator, please allow me to spend some time to introduce our distinguished panelists this afternoon. Our first speaker is Jose Antonio Rivas. He is a founding partner of X-Strategy and chair of the arbitration and international law practice at X-Strategy. He works as international counsel in investment disputes, serves as arbitrators and provide advice in public international law and investment law to sovereign clients, state-owned companies, and investors. He has 20 years of experience in international investment arbitration and public international law. He is former foreign investment director of the Ministry of Trade of Colombia, where he conducted a program to strengthen the state's readiness in case of investor-state arbitration and headed the drafting and updating of the Colombia International Investment Agreement model. And based on this model, he successfully concluded fifth negotiations with the states from Latin America, North America, Europe, and Asia. So welcome, Jose Antonio Rivas. And next, we have a professor from School of Law of Wuhan University, Professor Qi Tong. Qi Tong is a member of Wuhan University Institute of International Law. His research areas are mainly international trade law, international investment law, and international finance law. He also serves as an arbitrator at BIAC. Welcome. Our third speaker is Ren Qing. Ren Lyushi is a partner of Global Law Office. His practice is concentrated on international trade, dispute resolution, and antitrust law. In the area of ISDS, he has represented clients in several investment treaty arbitration cases, including winning a high-profile investment arbitration case for a host state and assisting 2 Chinese enterprises pursuing investment arbitration with foreign states. He had also worked at the Department of Treaty and Law at MOFCOM. Our next speaker is Carol Lee. Carol is a litigation partner in the Beijing and New York offices of Fillsbury Withrop Shawn Pittman. Her primary practice focuses on representing international clients in cross-border disputes and international arbitration. She has represented many international clients in confirming foreign arbitration award in the US. Next, we have Mariana Zhong. Mariana is a partner at Huizhong Law Firm, specializes in dispute resolution matter, including arbitration, litigation, mitigation, with a particular focus on foreign-related cross-border and international arbitration seated in China and overseas. Previously, Ms. Zhong represented 2 Chinese investors initiating an exit arbitration against a Southeast Asia state. And currently, she is advising an arbitrator in an ad hoc treaty arbitration against a state in Asia. Mariana also constantly provides treaty arbitration-related assessment to Chinese and foreign investors. And our last speaker is Samuel Wang. Samuel is an experienced dispute resolver. He practices as a barrister and regularly adjudicates disputes as an arbitrator. His practice covers a wide range of commercial disputes in which the governing law of the contracts spans from Hong Kong law, New York law, PRC law, and UK law. He also practices as an effective mediator. So thank you very much for tolerating me spend such a long time to introduce our very distinguished panelists. Now welcome our first speaker, Jose, to give us a presentation. Thank you.
Thank you. Thank you, Wen. Okay, so well, welcome again. The presentation that I have prepared for this panel is called 2024 Investor State Arbitration Panorama in China, and it deals with the Chinese investors abroad using the investor state arbitration system on the one hand, and on the other hand, China as a host state within the investor state arbitration system. Mainly, I will go through these two aspects through especially data. I'm not going to go deep into the cases because that is something reserved for the panelists. I want to reach some conclusions based on the information that we have in front of us. So the first thing, let's look into the outcomes of cases involving Chinese investors in using the investor arbitration system. Overall, we have a total of 19 cases so far of Chinese investors using the investor arbitration system, and most of them are pending. However, we can get some conclusions from the other pieces of information. One has been discontinued, which is telling that perhaps there was either no merit or there was no funding for the case, but it tells a story in terms of it was simply not followed up. One has been settled, which tells the story that perhaps there was some type of negotiation between the two parties, and two have been decided in favor of the investor, and three have been decided in favor of the foreign state. So overall, what we can say, at least from these figures, is that Chinese investors abroad are using the system in 19 cases. It's not an overwhelming use of the system. It is a use of the system that I would say is fairly moderate but active. So Chinese investors abroad, as we saw it this morning, are relying on the system to protect their investments abroad, both the SOEs and, as we will see later from some of our speakers, including Sam, also private companies, Chinese companies, private companies investing abroad. That's the first conclusion. And let's see in terms of the geographical trends. Where are Chinese investors bringing investor state, or against whom are they bringing investor arbitration? And here's some of the pieces that I find the most interesting, because we know that there's a big economic project by the Chinese economy, the Belt and Roads Initiative, etc. And that includes Africa, and that includes also Latin America and some countries in Asia. So, for instance, that being said, there's only 2 cases against African states. And that being said, there's only 3 cases against Latin American and Caribbean states. Most of the cases are in the region, number 1 in Asia. And what I find most interesting is that number 2 is Europe. And this is quite astonishing, because at least in my thinking, this is one perhaps of the reasons that the investor state arbitration system is somehow under pressure, because there are new players in the block. Clearly, China. Chinese investors have sued countries that are in Europe, including Finland, Belgium, Sweden, and there's some pressure because the whole set of economies in the world are changing. So moderate use of the investor state arbitration system. Now let's move into the China as a respondent state. Here we have 9 arbitrations, and 5 of which are pending. 1 arbitration was settled, and this somehow means that there might have been some merit, or at least to some extent, by the investor. Then there's 2 were favorable to China. Basically, China did not lose those arbitrations, and 1 was discontinued. The discontinuance may be for many reasons, lack of funding. Simply, the investors concluded that their claims might have not had merit. Ultimately, in those arbitrations against China, all in all, we can say that they have been slightly more favorable to China than to the foreign investors. But the conclusion of both is So far, when we look into Chinese investors using the system against sovereign states and foreign investors using the system against China, the conclusion is there's use and it's fairly balanced. There's no striking imbalance in that use of the investor-state arbitration system. These are the set of cases where Chinese investors have submitted investor-state arbitration claims. And what is perhaps most notable is that there is again a balance mix between the manufacturing part of the economy and the services part of the economy, which is very telling in terms of the level of sophistication that we now see in the Chinese economy. In terms of, again, geographical trends, the cases against China have mainly investors that come from Asian countries and in a lesser manner, investors that come from Europe. And here's the going back into the industries that again are related to not only primary parts of the economy but also services. We even have a case that involves arts and entertainment. So one basic conclusion is China has 107 investment treaties that are currently in force. Of these, 14 treaties were signed between 2006 and 2023, while the remaining approximately 86% date back from before 2006, which is, and why am I referring to those two dates? Part of it is because as we will see from Professor Chi in greater depth, part of this is to show that there has been an evolution in the bilateral investment treaty or the investment treaty that China has had. I had the honor and privilege of negotiating the investment treaty between Colombia, which is the state where I was born, and China, the bilateral investment treaty. And even at that time, that was about approximately 12 years ago or so, we could see that the Chinese bilateral investment treaty was evolving, coming from a defensive perspective, receiving investment, to going into a more offensive perspective, basically protecting their investments in the world. And it's a fascinating evolution. I won't bore you with specifics of the substantive obligations, but what we can say is that except for the older treaties which had a limitation, basically including expropriation or including somehow exclusively expropriation, into more modern treaties which have a broader set of obligations. These are some of the examples that we have of typical Chinese substantive provisions. So you see them there: prohibition of denial of justice, non-impairment standard, full protection and security, typical MFN, national treatment, and protection against unlawful expropriation, direct and indirect. There are some key parts of investor arbitration, whether you use ICSID or non-ICSID enforcement, as in the New York Convention. And finally, a set of basic conclusions, of which I have already referred to a few. First one, there is a real balance in the use by China and Chinese investors of the investor arbitration system, and that balance is somehow reflected in positions that China has adopted in multilateral forums. During this conference, I have learned or learned in greater depth the position of China with respect to UNCITRAL. As you know, the European Commission is pushing against investor-state arbitration, trying to create a multilateral court, and one of the questions that I came to this conference with was, what is China's position? Does China want to have a multilateral investment court? Does China wants to have nothing, or does China wants to have something else? And what I found, explained by another professor here, is that China, I understand, wants to have an appellate mechanism. And when I said, why is that? And so they explained to me, well, because we're using the system, we want to build upon the system, and there's really no incentive to have a multilateral investment court. There is an incentive, perhaps, to be more consistent within the system, and thereby there is a push to adopt the notion of an appellate mechanism, which would leave the current panels of investor arbitration as or tribunals as they are, but there would be a second level of review under perhaps an ICSID appellate mechanism. And the last perspective that I wanted to share is emphasize that the practical use of investor arbitration it seems not to be too aggressive, and this we learned this morning in the discussion of SOEs. There is a pause and there is a lot of reflection before a state-owned company, Chinese, takes the step to sue a sovereign state, which I think somehow is quite wise, because an investor arbitration claim is a hard step. Sometimes when they make it, economic relations are severed, and therefore that wise moderation is also a reflection of what I understand being the position of China. And with that, I'll stop and give the floor to Wen. Thank you.
Thank you very much, Jose, for the very informative presentation. And I'm really happy to see that the calculation last night I did is correct, that there are 28 cases where China or Chinese investor involved, where 19 cases where the claimant is the Chinese companies, and 9 cases where Chinese government as the respondent hosts the state. So I know that Mariana would like to make one small comments to Jose's presentation. Mariana?
Yes, thank you. And just very briefly, I have some comments on the enforcement of treaty awards in China. I see that Jose is quite optimistic, but while this situation perhaps is a bit different in China, we know that China enacted a new law relating to foreign sovereign immunity, which entered into effect this January. It appears now that theoretically it is possible to enforce a treaty award in China, but in my view, it would still be quite problematic in reality, because if it is a non-ICSID award, the applicant would not be able to rely on the New York Convention, because China has made a reservation of commerciality under the New York Convention. And if the award is actually an ICSID award, the applicant would still encounter uncertainties because China has not nominated any competent court to handle such application for enforcement of ICSID award, pursuant to Article 54 of the ICSID Convention. And adding to this uncertainty is, even if all these obstacles have already been removed, specific execution is still almost impossible unless the foreign state has waived immunity on execution separately. So that is my comment. Thank you.
Thank you, Mariana. But even though there are a lot of problems, but we still need to have hope to the future that there will be a lot of very exciting revolutions, developments in the future, that we believe the Chinese government would take some actions, especially considering nowadays there are so many cases kind of coming up. So next, we will have Professor Qitong to talk about the modernization of BITs of China-related ISDS cases. Mr. Qi.
Thank you for introduction. I would like to I would like to start by congratulations WAU and BAC for the outstanding organization of this event. It's a great honor for me to join this distinguished panel discussion. Our panel focus on China's participation in ISDS system. So as we all know, investment treaties are one of the most important instruments of international investment arbitration. And I would like to share some very preliminary observation on the modernization of China's investment treaty based on China's ISDS cases experience as a base for the following discussion. China's investment treaty practice can be traced back to 1980s. At the very beginning of the process of China's reform and opening up. So till now, there have been almost 145 bilateral investment treaties and 19 treaties with investment provisions. So in the IIM regime of China. So among the 145 bilateral investment treaties, around 2/3 of them were concluded prior to the 21st century. So when we talk about China's participation in the ISDS system, we can't ignore that a large number of cases were initiated based on China's earlier investment treaties. According to my status, we have 25 cases initiated by Chinese investors, and we have 10 cases against China. It's a little bit different from yours. So within these 35 cases, there are almost 16% of the disclosed ISDS cases based on the first generation of Chinese investment agreement. So to figure out what are earlier investment agreements, the Chinese investment agreement can be divided into several generations in terms of their difference in substantive treatment and procedural aspects. So the first generation, which concluded from 1982 to 1997, accounting for more than 51% of the effective Chinese investment agreements. It did not stipulate for national treatment and includes very narrow constructed ISDS clauses. And most likely limits the scope of arbitration to a dispute involving the amount of compensation resulting from expropriation. So the second generation concluded from 1998 to 2005, which provides investors with post-establishment national treatment and a broader ISDS scope. The third generation concluded from 2006 to 2019, and the fourth generation, which come from 2020 to present, which many moves toward a regional and modernized legal framework for foreign investment promotion and protection. So the term earlier investment agreements here refers to the fourth generation. So earlier, according to my status, earlier investment agreement account for over half of the effective Chinese IRA and have not been modernized so far. So the large stock of earlier Chinese investment agreement and its frequent use in China-involved cases may result in regulatory deficiencies and application difficulties. So one of the most serious regulatory deficiency is the scope of ISDS. So as mentioned above, most the first generation of Chinese investment agreement limit the scope of arbitration to a dispute involving the amount of compensation resulting from expropriation. These limitations are not conducive to the protection of the outward FDI. And the second one is the vagueness of the treaty language used in the first generation Chinese bilateral investment treaty, which left a lot of room for the discretion of individual arbitral tribunal. So, for instance, when interpreting the term disputes involving the amount of compensation for expropriation, some tribunals supported a broader interpretation, where others interpreted it in a narrow approach. Earlier Chinese investment agreements may also have spillover effects with the MFN clause. And the China-involved cases also show us the inconsistency and uncertainty on the application of Chinese investment agreements to Hong Kong and Macau special administrative region. So we may also find the multiple overlaps of Chinese investment agreements between old one and the new one, between bilateral and regional level, and the insufficient coordination between Chinese investment agreement and its domestic law, especially the new foreign investment law, which entered into force in 2020. So from a global perspective, we can find in the past decade a number of economies, such as the European Union, Brazil, Australia, Indonesia, and Pakistan, they have reviewed or been reviewed their investment agreement stocks. As for the modernization of China's investment agreement regime, several options were adopted from 2001 to now, such as amending earlier investment agreements by protocols, replacing earlier treaties by a new one, or investment chapter in FTAs. So consolidation the investment agreement network by regional investment agreement, especially the China-ASEAN framework and China-EU network. The first one is developing an investment agreement model. And the fifth one is a joint interpretation of its investment agreement. The third one is terminating an old treaties. So the modernization process of China's investment agreement regime can be divided into two phases. The first phase lasts from 2001 to 2010, when some earlier investment agreements, most bilateral investment treaties concluded between China and the European countries were amended by protocols or replaced by new agreements. So the second one lasts from 2011 to present, when the forecast of China's investment agreement making moves from bilateral to FTA, and China accelerated its regional investment agreement rulemaking. So it must acknowledge that although China has the intensive to conduct its investment agreement modernization, it will not be effortless given the large number of the existing agreements. So in the process of investment agreement modernization, China should remain prudent when updating the earlier agreements. So my suggestion here is, firstly, the treaty relationship between earlier one and the new one, between bilateral treaty and regional treaty should be addressed to avoid potential problems in investment treatment and arbitral practices. So the second one is a case-by-case approach is suggested on the issue of the application of Chinese mainland investment agreement to the SAR, such as Hong Kong and Macau. And the third one is the correlation between investment agreement and China's domestic law should be enhanced at both the substantive and procedural level. So that's all for my speech, and thank you for your listening.
Thank you very much, Professor Qi. Jose, that I recall in your slides, you mentioned that the Chinese BIT's involvement, evolution of the Chinese BIT from a defensive approach to offensive approach. So maybe you would like to make some comments to Professor Qi's presentation.
Thank you, Wen, and thank you, Professor, for the presentation, for educating me on the various levels of generations of Chinese investment treaties. In fact, my approach was way more practical, because I was negotiating the treaties, and what I could see in our research when we negotiated the investment treaty with China was that there had been this transition that Professor Qi was describing. The one aspect that I remember at the time was that Chinese treaties used to only refer to expropriation, and then that evolved into embracing other provisions, substantive provisions, including national treatment, MFN, fair and equitable treatment, etc., which was a big change. My understanding, and I think that this might be something that that our panelists may want to comment later on, is that because the investor-state arbitration system is a system that relies not on a or one multilateral investment treaty, like type of WTO treaties, but it relies on a multiplicity of investment treaties. You have multiple generations. As you know, there's more than 3,300 treaties in the world of investment treaties. So with various generations, one of the fortunes that investment treaty arbitration has is that it has so many treaties that I strongly believe that it would be very difficult to finish the system. It's like having so many fish in the pond that it's not going to be finished. But at the same time, the disadvantage is that if an investor relies on an old generation treaty, which has not that many protective provisions, then that treaty may not be as advantageous for the investor, for the Chinese investor. So if you have a very old generation treaty, if you have a more modern treaty like an FTA, like fourth generation and perhaps fifth generation, or perhaps sixth generation, when you have the modernization between bilateral investment treaties and free trade agreements, which Professor Qi is proposing, then the foreign investor of China will have a greater benefit. But that's one of the challenges, the type of agreement that you can apply. And it's something that cannot necessarily be decided on the short term, because if you're an investor in a state with which you have an old generation treaty, that's what you have. There's very little that you can do but renegotiation takes a long time. That's my comment.
Thank you very much. I will not spend more time, but invite our next speaker, Ren Lu to talk about his experience and thoughts about China as respondent host states in ISDS. Welcome, Ren Qing.
Thank you very much, Ms. Dai Wen. Yeah, I prepare only one page of slide, the cases in which China is the respondent. I know just now Jose put also a similar page, a similar slide, and in that slide, there are 9 cases. Here, it's also 9 cases, but it's a little bit different because I exclude one case in which the Taiwan province is the respondent. In this slide, only the central government of China is the respondent. And why there is still in total 9 cases? Because I count one case twice. Yeah, so you can call it is one case or you can call it 2 cases. That is the case Wu against China. So that is the difference between my slide and the slide of Professor Jose. Yeah, so I would like to make 8 observations about these cases, these 9 cases. The first is that the first case against China was brought in 2011. 2011 means that after 30 years of China's opening up, no single case had been brought by foreign investors against China. It is until, after 30 years after China's opening up, the first case came up. And it seems that the cases grow quickly. Yeah, it seems at least in several years. If we say that from 2011, 12, 13, one case in 3 years, and 14, 15, 16, one case in 3 years. And 17, 18, okay, one case, 2 years. One case in 2 years. And in 2020, 2 cases or 3 cases. Okay, so you can see the trend of the increase of the cases against China. Finally, in 2021, 2 cases. At that time, okay, we still, maybe somebody will still expected that the case will increase and increase. But in 2022, 23, and this year, no new cases. At least no new cases was publicly known. As far as I know, there are some cases, maybe they are under the preparation or the notice of dispute or the request for consultation was sent by the investor to the government, but they either had not been registered or has not been made public. Okay, this is in total 9 cases. 9 cases means that it's only less than 1% of the total ISDS cases in the world. Till the end of 2023, there are 1,332 ISDS cases worldwide, and China only account for 0.7%. I think this to some extent, it indicates a success of Chinese government to, cultivate a friendly business environment, or the Chinese government has successfully resolved some disputes with foreign investors in the early stage. So no formal arbitration came up. Especially taking account that every year there are more than 100 billion new FDI coming into China, and totally there are. I find a figure from MOFCOM, 2,800 US dollars of FDI accumulatively into China. So the cases, I think the number of the cases are quite small. The second observation is that the plaintiff or the claimant, the claimant, the home state of the claimant, I do not know whether it is by coincidence or not. All these cases were brought by investors whose home state is among the top 10 source of FDI. I mean, Singapore, UK, even Malaysia, all these cases, and Japan, Germany, all these cases are among the top 10 the source country of the FDI into China. And no North American, South American investors brought arbitration against China. Of course, no African investor and no Australian investor. And eight cases were brought by investors from developed countries. Only one, Malaysia. The first case is from Malaysia, a developing country. More interestingly, among all these cases, no big multinational companies had initiated arbitration against China. All these cases were brought by small or medium-sized enterprises or natural persons. The Song Yu and the Wu case, they are brought by natural persons. This third observation I would like to make is that all these cases were brought under BIT, bilateral investment treaties. No cases were brought under FTA, regional trade agreements. It's interesting because in recent years, China has concluded about 20 FTAs with investment chapters. And these investment chapters, they have, more comprehensive substantive protection preventions, and they also have broad arbitration, broad scope of consent of arbitration. But no investor had used FTAs to sue China. I know at least in one case between China and the home state, there are at least two treaties. One is BIT, concluded in 1980s, the so-called first generation BIT. And there are another FTA concluded in, I think, 2009 or 2008. But the investor chose not to use the FTA. It's interesting. I do not know the reason. Among the BITs, most of the cases were initiated under the first generation BITs. And as Professor Qi just mentioned, that these first generation BITs, they have one important characteristics is that they limit the arbitration consent scope, limited to disputes involving the disputes of the amount of expropriation compensation. And that is the heart of the dispute in all these cases. The fourth observation is about the sectors involved. Among these 9 cases, at least 6 involve real property development. Real property development, land, housing. You can understand in China the rapid urbanization, so there are a lot of or potential disputes in China. So I think that is understandable. The 6th observation is these cases involve a number of provinces of China. Hainan province, 2 cases. Shandong province, 2 or 3 cases. Jiangsu province, 1. Anhui province, 1. And Sichuan province, 1. The 6th observation is that the measures and the issue in these cases, it's interesting that some of the cases involve biodiversity and environment protection. I mean, Chinese government, for reason of environmental protection, take some measures, and that measures lead to some dispute with the foreign investors. For example, the Asia Force against China. This case is about a natural reserve and the new established panda park. It is totally for public interest, for environmental protection. The 7th is that till now, Chinese government has not lose any single case. Either the case is pending, or the case is settled, or the case is discontinued, or the case is decided in favor of China. The first case is settled, not decided. I think it's understandable. The first case for China, so maybe settled is most appropriate way to resolve this dispute. And the second case decided in favor of the state. The first case entered into the arbitration stage, China prevailed. And the 5th case discontinued because that claimant is a very small company. They do not have sufficient funding for their pursuing their case. No matter whether they have any merits about their case, but in any way they discontinued the case for a lack of funding. And the 6th case is very interesting, discontinued in exit, because I think my personal opinion is that the claimant, they made a mistake. It's not an exit case, but they brought the case before exit. So they have to give up that case and file a new same case at PCA. And the Asia Force case, China prevail. That is the China prevail convince the arbitration tribunal to that they lack the jurisdiction. The final observation is about how China achieved the good outcome so far. Yeah, I think Chinese government has established a relatively successful, effective working mechanism to defend China in investor-state arbitration cases. And in China, it is MOFCOM, and specifically, it's Department of Treaty and Law of MOFCOM who defend China in these cases. And apparently, before China defended in ISDS cases, they have learned a lot in WTO dispute settlement. There are some similar, they can share some experiences when they defend them in ISDS cases. And the central government, they coordinate with the first MOFCOM coordinate with other departments within the central government, and then they coordinate with the local government, the provincial, the municipal, the county governments. There will be a working group to defend China. And As to external counsels, you will see that some of the cases are defended by, a pair of law firms. One is international law firm, and the other is the Chinese law firm. Some of the cases, and some of the cases were represented by a Chinese law firm plus a barrister. And in some other cases, Chinese law firms represent the Chinese government independently, only a Chinese law firm. So I think I think it's based on the facts of the case, the particular circumstances of the case, and the government choose a best way to organize their government lawyers and their external counsels. Thank you for listening. This is what I would like to share with you. Thank you.
Thank you very much, Ren 律师. Carol, would you like to make a comment on what Ren has just said?
So brilliant observations by Renqing, especially the trending of the ISDS cases against China as the respondent. Something that might be relevant, and perhaps other experts on the panel and in the audience can further comment later, which is the implementation of the China's foreign investment law. The law was implemented in 2020, and it replaces the previous regime of laws governing foreign investments. Some of the key provisions of the law include, national treatment, meaning foreign invested enterprises are treated the same as domestic companies once established. And another provision is the negative list, which specifies sectors where foreign investment is restricted or prohibited. And the third is strengthening intellectual property protections against forced technology transfers. I think this the implementation of this law might have some relevance as to the decrease in cases of investment cases against China. So that's my comment.
Thank you very much, Carol. I get a reminder that in this session we only have 30 minutes remaining, but I note that we started a little bit later, so maybe we'll kind of slightly delay a bit. Before we move into the discussion from the investor's perspective, I'm trying to pose a kind of tough question on Mr. Renqing. Since you just mentioned that the monetary amount of FDI here in China is quite huge, quite large, high numbers. However, China as the respondent host state in ISDS cases, only 9 cases, so very small. And also you had one observation saying that multinational companies seldom kind of sue China as respondent. So my question is that based on your working experience in MOFCOM and now have so many first-hand experience in this area, what are their concerns? Do they kind of afraid to sue China when they think about, oh, how is my future of business development? Is that the concern or anything others that kind of in reality prevent them to actually take serious actions against the government in case where they suffer something here? Yeah.
I need to answer the question now? Okay.
I think the audience is waiting.
It's really a tough question. I understand that there are a lot of reasons, I guess, but one reason is that I think that two reasons. The reason is the first reason is that the business environment in China is improving. That is the first reason. The second reason I think is that the multinational companies, they have a lot of means to resolve their concerns or problems or even disputes with local governments. They can, they have a very, most of them, they have large government affairs team. They can, communicate with different various agencies of government to try to find a mutually acceptable way. And there in China, there is also some other means. For example, under MOFCOM and the local Department of Commerce, there is a center to specifically established to resolve complaints of foreign investors, which they can use, the investors can use. And there are also administrative review, administrative litigation in China, they can also use. So I think for most of the multinational companies, ISDS will be their last resort. So they have many of other means, recourse, so they do not have to use ISDS. Thank you.
Professor, just one follow-up question. Given that, and yes, to be answered here, just do you think that some big companies are also taking advantage of the other means of solving disputes in China? And I'm talking in particular about BAC, BIAC, but the other arbitration centers. Do you think that is somehow having an effect? I mean, we know that many companies, foreign companies, have subsidiaries in China, and of course, other means of solving disputes may be available to them. Do you think that is happening? I have no data about that, but I'm interested to learn.
Thank you. Yeah, indeed. First, some of the disputes with government may arise first as a commercial disputes between the foreign investors and their Chinese partner. So if the commercial disputes cannot be handled properly, they may involve to a dispute against the Chinese government. For example, if the court did not resolve a commercial dispute between Chinese and foreign investors properly, then they may have concerns with Chinese court and then Chinese sovereign state. So I think the other judicial system, the judicial system, the overall, the well working of Chinese judicial system help to reduce the likelihood for the foreign investor to sue Chinese government. And for the arbitration institutions like BAC, I understand that, for example, there are some public public-private partnership projects. In China, these kind of projects can be resolved. Some of them, I cannot say any of them, but some of the PPP projects, they can be resolved through arbitration. So BAC and other Chinese arbitration institutions, they help to resolve this kind of disputes and then avoid the disputes to involve as disputes against China as a government. Thank you.
Thank you. Thank you very much, Ren Lyushi's very great presentation.
These are all my personal information. Personal, just personal.
Yeah. I think Chinese people that we inclined to have a peace and settlement, that we cherish the dispute can be resolved amicably. So either that in administrative level or in this commercial arbitration level, there are a lot of approaches that foreign investors and also entities, they may find recourse. So yes, it is as it is. That's only 9 cases so far where China government as the respondent host the state. So our remaining 3 speakers will discuss the topic from the investor's perspective. And our first speaker is Samuel Wang. Samuel, please.
Thank you for inviting me to speak today. My involvement with investor-state dispute arises out from representing a Chinese party in taking an action against Finland in an investment treaty dispute. And since this is already disclosed and in the public domain because of Finland's rule in terms of transparency, so I can mention this without reservation. To start, actually, many speakers already mentioned today about SOE and dispute resolution by way of investor-state arbitration. So today I will focus on private investment instead of SOEs. Now, we all know that the purpose of BITs are, in the first place, to promote investment. And in order to promote investments, then the host country must protect the investors' interests. And so, in relation to the two signatories to a bilateral investment treaty, each of the country would be interested to attract foreign investment, and then each of the countries would be there to protect, to have provisions to protect the investor against certain practices that are not acceptable. So with the ascending economic strength of China, China has changed from being a recipient of investment to an exporter of investment in host states. And this is particularly so in view of the Belt and Road Initiative. So as more and more Chinese enterprises going out to invest in outside countries along the Belt and Road, more and more are the chances of risks of disputes arising from the performance of the contracts and arising out from country risk and actions taken by government regulatory bodies. So in relation to normal transactional risk, these are usually handled well by lawyers advising investors and how they structure the terms and conditions of the, such as the joint venture agreement or the transactional contracts. However, we all know that in relation to transactions, nobody would like to rely on the courts of another country to dispense justice. So usually, as said earlier this morning, most of the transactional or contractual disputes would be handled by arbitration in a neutral venue, such as Hong Kong or Singapore. And upon different sets of rules, such as the HKIAC administered arbitration rules, or SIAC rules, or ancestral arbitration rules. Now, but one thing that is often overlooked in the process is that there is a second level of protection against the Chinese investor going out, and this by way of the investment treaties entered into by China that would enable Chinese investor to be entitled to certain protection. Now, so the protection against, for instance, the risk of change of government leading to change of policy or arbitrary application of certain administrative measures that may amount to an expropriation of the project or withdrawal of a license given for mining, for instance. So we heard today there are lots of cases of investment disputes, such as in relation to construction projects, in relation to mining rights, in relation to forced deprivation of assets, and the cancellation of licenses that has been lawfully granted. So, so we saw earlier on when Jose told us many of these disputes actually have been resolved. Some are still pending, some are settled. So what I would like to take you to is one of the so-called template of such rules. And by that, I would refer to the Finland-China BIT. And the first point I like to highlight is the definition of investment actually is very widely drafted. And it involves every kind of assets that you can think of, including movable and immovable property, shares and debentures, claims of money or other performance having an economic value, intellectual property rights, know-how, and goodwill, and business concessions conferred by law and permitted by law. Now, all these are classified as investments that can be protected. And who are the investors in the context of a Chinese going out? It can be a natural person, a Chinese national, or it can be any Chinese legal entity, including a SOE. So in typical bilateral investment treaties, it would guarantee the investor by a term constant protection and security. By that, it means a proactive mandate by the government of the recipient state to the investment to make sure that the investor's properties and personal safety are protected. So it's not as if something happened, then they come in a police car and protect you. It means that they should do that proactively. And then also, normally in measures that there would be no unreasonable discriminatory measures that is targeted against the investor or investor from a particular country. Now, so the investors can manage, use, expand, sell, dispose of the investment at will. And so you cannot unreasonably and discriminatorily prohibit the investor from selling his investment or otherwise dealing or managing it. Now, the third thing that is being protected is fair and equitable treatment, that the investor should be treated fairly. And the first term that you see all the time is national treatment. So you would be treated no worse than the national of that particular recipient state. But you may be treated better under a most favored nation clause that is normally in place in such BITs. And of course, one of the most important things that is that there should be no expropriation without compensation, proper compensation, even though it may be in the public interest and without discrimination. So when you wish to take a measure, the host country, to do certain things, the investors' rights must be respected and be compensated for. Now, one further important provision that you will normally see is that the transfer of funds related to the investment in and out of the country would be permitted. So you can remit in and out the amount you invested, the dividends, the interest, the royalties, the service fees, etc. Now, these are very important provisions because if you go into a third country and invest and they permit your investment but doesn't permit you to take out the money, so it would create serious difficulties at the end of the day. So these are the measures. And so many times in relation to Chinese investment to Belt and Road countries, you are going into an unknown territory with a set of law that you are not familiar with and the language that you do not understand. So how can your interests be protected? One of the ways in relation to contractual disputes is, as I mentioned earlier, by commercial arbitration, international commercial arbitration. The second tier, that is at a higher tier, is by way of investment treaty arbitration to protect your interests further. And in a lot of the bilateral investment treaties that I've read, they all have a dispute settlement provision. And it provides for a tiered arbitration. That means, and Teresa Chen mentioned that as escalation clause. That means you try to negotiate or mediate after written notice for 3 or 6 months. And when that process or that step is taken and completed and resulting in no settlement, then you can commence in an arbitration to have your day before the tribunal. Now, this, in relation to bilateral investment treaty, how you commenced the arbitration is at the discretion, the choice of the investor. So for a Chinese going out to invest in Cambodia, for instance, it's the Chinese that would be in the driving seat as to how this arbitration is to be conducted. There is a provision. The provision say you can go to the competent court of a contracting party, or to exit arbitration, or to an ad hoc arbitration tribunal. Now, and to a tribunal of 3 arbitrators to resolve the disputes. Now, this, of course, a tribunal of 3 arbitrators would be far preferable to the domestic court of the contracting state, the host country, because there may be political or other reasons that the request for adjudication by an investor would not be favorably be looked upon by the courts of the host state. This particular clause actually poses some difficulties, and the difficulties is called the fork in the road consideration. So you can have a choice either going to the local court and then alternatively go to seek relief in an international arbitral tribunal. And I would suggest that going to an international arbitral tribunal would be far preferable. Now, but many times, the agreement may include a clause saying that for certain matters, you are going to refer first to a local administrative tribunal to decide first before you do anything else. So in those circumstances, the investor may have to go before, for instance, a taxation body to have that dispute dealt with, and failing the administrative body dealing with it fairly and equitably, then you move on to the next stage by way of investment dispute arbitration. However, when you do that, then the defending state would have an argument. You have already made an election and you went to my tribunal and you can no longer go for investment dispute arbitration. This is precisely what happened in my case in Finland. This is quite an interesting case because my client went to Finland to invest because that investment was promoted together with CCPIT in China. And he looked at the investment and sought to set up a distribution center in the city of Kouvola in Finland, which is the end of the railway line leading to Europe. So a logistics center for distribution of Chinese goods. Now one of the conditions that was given in the approval to him to have that investment is that he should invite at least 50 Chinese investors to go to Finland to invest. And because of that provision, he invited hundreds of Chinese investing or possible investors to go to Finland to have a look at the location. The immigration department has a complaint arising out from that. How come so many visas issued to Chinese? You must be dealing with illegal immigration into Europe. You're the conduit of an illegal scheme. And then he was arrested. The arresting was dramatic. There were 200 police with guard dogs and helicopter descending on his center, arrested more than 100 Chinese, he himself, his staff, and his customers. And they were bundled off for questioning. He was held 6 months incommunicado, cannot communicate with anybody. And then his relief, he asked for bail, for being bailed out, was denied repeatedly by the court. And after he was released, having no charge against him, after months, and then the possessions were not returned for a year, he sued the government in court for negligence in tort. And then when this investment dispute arbitration came about, the government's defense is that you have already taken a choice. This is a fork in the road. You went to the court of Finland on tortious grounds against the government body. You can no longer rely upon the cause of action in bilateral investment treaty grounds. And for that, we have to spend a lot of time and money in arguing about that. So actually, when I think in the first place, I would advise actually Chinese investors are very shy about suing the state. It's like David versus Goliath. And so David doesn't want to move. Chinese doesn't want to fight unless being forced to the wall. And so they have scantily used BITs, what is accorded to them to protect their interests under the BITs. But actually, I would suggest that Chinese investors should look more into the BITs as an option to protect their interests. But it does not mean that commencing a BIT necessarily means going the full way, because once you commence it, you can still continue to mediate or negotiate and explore ways of settlement without going through the whole process leading to an arbitration award. In this case, we raised an arbitration based on ad hoc arbitration commencing out from Hong Kong. And we have a panel of 3 arbitrators, one appointed from Hong Kong, a Court of Final Appeal judge, one from SCC in Sweden, and then the presiding arbitrator was Lord Mance from the United Kingdom. And we were hoping that this would set up some precedent in relation to fork and road to guide how in the future this would be looked at in terms of with the guidance of the court. But unfortunately, my client contracted cancer and died before the award was rendered. And so we actually settled out of court in view of his death. And so what I say is that nowadays there are so many Chinese investors going outside to invest in Belt and Road countries. It is useful to have legal advisors advise them as to how to rely upon the BITs to assist the investor, including shopping for the place of a special purpose vehicle to commence that investment so as to protect Chinese investors' interests. So thank you very much for my short presentation. Thank you.
Thank you, Sammy. Time-wise, that we are a bit late, but I understand that Qitong still want to make some comments, so please make sure it's short. Thank you very much.
Okay, thank you. Very short comments. I believe the case against Finland mentioned by Mr. Wang precisely illustrated that Chinese investors, including SOE, are facing more severe investment environment, both in developing country and in developed country, and which also witnesses the importance of the ISDS mechanism to investment protection. So along with the increase of ISDS cases initiated by Chinese investors, So I'm very glad to find Chinese lawyer play more and more important role in this system, like our distinguished panelists here. And however, Chinese arbitration institutions still did not achieve the zero breakthrough in managing ISDS disputes. So I hope the day come earlier. And the BIC, I know, as we know, the BIC already have rules for investment arbitration, and I hope maybe the BIC will make the first goal, and we can deal with investment disputes here. Yeah, that's my short comment. Thank you.
Thank you, Professor. Carol, it's your turn.
Yep, oops, sorry. Okay, let's try again. Okay. Well, great overview of BITs by Samuel. Just a couple of additional key points for Chinese investors and some takeaways for them, which is that well, ISDS cannot, one key point is ISDS cannot overturn local laws that violate trade agreements, but it can give monetary damages to investors adversely affected by such laws. And notably, ISDS can only be brought by foreign investors to sue states under the treaties because states are the parties to the treaty. And only states can be held liable to pay damages for breach of the treaty. However, this is a one-way street and it doesn't work the other way around. That is, states have no corresponding rights to bring an original claim against a foreign investor under the treaties because investors are not parties to the treaty and therefore cannot be in breach of it. So when we see a decision in favor of the states, what it really means is that the state has not been ordered to pay damages to the investor. If a state wants to sue an investor, it will have to do so through its own domestic courts. And it is essential and critical for Chinese investors to understand and comply with the host country's laws. These may include requirements for joint ventures, restrictions on foreign ownership, and sector-specific regulations. And just overall recommendations. First, due diligence. Investors should conduct thorough due diligence on the legal and regulatory environment of the host country. Understanding local laws, tax regimes, and political risks is critical. Second, study the treaty landscape. Investors should conduct a thorough investigation and review of treaties that may apply to the investment. If necessary, structure the investment to benefit from favorable treaty regulations. Third, obtaining legal advice. Investors should engage with legal experts familiar with international investment law and the specific treaties between the relevant countries, such as law firms, global law firms who are experts in this type of legal services. Fourth, investment insurance. Investors should consider investment insurance options to protect against political risks, such as expropriation, war, and civil disturbance. Fifth, local partnerships. Investors should consider forming partnerships with local firms that can facilitate smoother operations and compliance with local regulations. And sixth, dispute resolution mechanisms. Investors should be aware of the available dispute resolution mechanisms under applicable treaties and agreements to ensure access to fair arbitration if needed. And by leveraging these treaties and agreements, investors can better protect their investments and navigate the complexity of international markets. Thank you.
Thank you very much, Carol. May I first invite our last speaker, Mariana, to finish the talk, and then we do the comments parts.
Okay, thank you. And as the last speaker, I do not want to delay your coffee break further, so I will try to be very fast. My topic today is evidence and evidence. As arbitration lawyers, we all understand the importance of evidence in proving our case. However, in practice, we have seen investors who suffered disadvantages during the arbitration because they cannot find evidence to support their allegations. And this happened either because they did not maintain a good record of evidence, including company files, transactional documents, tax filing records, or because they did not pay attention to document when important meetings take place. So I would like to share 3 practical experiences based on which I will provide takeaways for investors and their counsels. My first experience relates to the investor's burden of proof to show his making of the investment, the flow of his fund, and also that he made the investments legally. As a first step, investors need to show that they made the investments in the host state. To prove this fact, he needs to show that the flow of the fund from the investor to the local entity or to the local investment, and they need to present evidence such as commercial contracts, wire transfer statements, importation custom clearance, etc., to show that they made the investment using their own fund or through their own entities into the territory of the host state. This could be quite problematic if the investor purchased materials, equipment, and wired money into the host state using lots of unrelated third parties, using bank accounts that cannot be linked to the investor or his own companies. So heavy challenges will be made by the state to argue that the investor did not make the investment, or did not make the investment using his own money, or did not make the investment legally, or that the investor has committed money laundering or fraud. So this happened in one of our cases that we handled. Then the investor spent lots of time and costs trying to sort out all those payments made into the host state to show that they originated from the investor, they were clean money, and there was no fraud. The investor, of course, does not need to show that all the investments were made using his own money. It is okay to channel other sources of fund as long as the investments were made legally and in accordance with the law of the host state. So my second experience relates to the investors' documenting of important meetings and communications with the host state. In investment arbitration, violation of due process is perhaps one of the most pleaded grounds by the investors. In many cases, it is not, for example, it is not why the licenses were taken, it is how it was taken that was always in the center of the dispute. So it is important for the investors to document important meetings and conversations with the host state, with the government officials. The investors could do so by creating contemporaneous documents, including meeting minutes and notes, or through send and after email or after letter to confirm the occurrence of the meeting. I must emphasize that once a contemporaneous document has been created, the investor should not alter the content of the document, because the host state will apply to examine that document to see whether that document was authentic and whether that document was prepared for the mere purpose of the arbitration. So my third and last experience relates to the investor's use of factual witness. This is a quite sensitive issue because the investor and its legal team are fighting a war against a giant sovereign state. The powers are drastically unequal. The host state could adopt all types of measures to intimidate the witness or harass the lawyers or the experts of the investor. For example, the host state could have a special team located at a third country or a place of nowhere to hack into the investor lawyer's email system in order to plant virus or to steal sensitive information. And the host state could secretly harass the witness or relatives of the investor or relatives of the witness It could put the lawyers on blacklist, and it could arrest the local lawyers of the investor, which provides legal opinions on the local law. So these are not new to investment arbitration, and investors should be warned and prepared for these potential threats. Because of this very unique feature and potential threat, it is often challenging for investors to find witnesses who are willing to testify against a host state. We have seen in some cases where the factual witness initially agreed to testify, then withdrew his agreement. So based on these experiences, my takeaways for the investors and their counsels are the following. First of all, investors should simplify the flow of their funds into the host state. They should document and preserve all the transactional and communication documents with the local partner and with the host state, in order to show that they made the investment and they made it illegally. And second, investors should transfer their evidence outside the host state before the dispute escalates into arbitration. And thirdly, investors should take evidence of their investment by taking photos or by recording videos while they still can and while they are still in the host state. Because more often than not, once the dispute escalates, the investor may not be able to access their properties in the host state. And more often than not, the investor will have to leave the host state for their own safety purpose. And last but not the least, investors should identify potential witnesses who are important for their cases and make sure that these witnesses are returned to their safe place and not within the threat of the host state. That concludes my presentation. Thank you.
Thank you very much, Mariana. Very valuable observation and down-to-earth advice. Very good. I received a message that online there are tens of thousands audience hearing this panel, and we receive questions from online. So I discussed with Jose, and we decide to post these questions and spend a little bit longer time here. We had a good question online by Lin Yating, and the question is about the complaint mechanism in China, how it is used in China's local remedies in resolving ISDS cases. I wonder these disputes are resolved as commercial disputes before courts or resolved as administrative disputes under administrative litigations. Probably Renqing would be the best speaker to answer this.
Yes, we did some research about the complaining mechanism. I think this mechanism has a very long history. I think in maybe in 1990s, in some provinces, this kind of mechanism has already been established. And under the new foreign investment law, in the law, there is a prevention require the government at different various levels to establish such kind of mechanism. So nowadays, you will say in every province, maybe even in every municipality, there are such complaining center, sometimes under the Department of Commerce or under some other government agencies. These kind of centers, not many of them publish their working achievements. Very few publish some of the cases they have handled, or they will provide some statistics. Okay, in 2022 or 2021, they have received how many cases, and they, resolved how many cases. Actually, not all these complaints are about a real dispute. Sometimes, I think there are a lot of kinds of complaints, some problems, or not related to an actual dispute. They are not going to sue the local government. They just want to raise maybe an issue about the business environment in general, or about the interpretation or application of Chinese law in that region in general, or or so. So I think there are a lot of kinds of problems you can raise before that center. And normally when they receive this center, when the center receives these complaints or problems or issues, they do not have the power to resolve that by themselves. They will coordinate. They will find which government agency is the right agency to, or which agency caused this problem, or which agency is responsible for resolving this issue. So they will refer this to that agency or ask the complainant and the agency to come to sit together, and or if that doesn't work, they may escalate that issue to a higher level, or for example the mayor or the governor, and then to maybe find a solution. I do not know whether any complaint can be finally resolved. I do not know. So I'm not sure whether I answered this question, but this is what I have. Thank you.
Thank you very much. If there's no further comments that are eagerly to make now, we will conclude this session. Thank you very much for the patience and listening. Thank you.